In this video, we're going to talk about Calvary SPV and what they have been doing to push the debt collection lawsuits that they have out there for people. They're buying up a ton of Citibank. They're buying up a ton of other credit card debt, and they have hired a law firm that is trying to make a name for themselves and being very aggressive. Very aggressive. In this video, I'm going to tell you some of the things that I'm going to tell you all of the things that you need to watch out for, but I'm going to also get into something that I've never gotten into before, which is some specifics about a case that I see Calvary using, and some of the times I see some of the other debt collection attorneys use it when they motion for a summary judgment. Now, just to review, and if you've ever been sued by a debt collector, you've probably gotten a notice. If you've responded, or even if you didn't respond, you maybe have gotten a notice where they were going to motion for a summary judgment, and they will motion for that summary judgment based on their statement is that there's no law and legal argument that is has any material facts that remain to be litigated. So what they're stating is that everything that they've given, it's factual, everything is correct, and they just want the judge to go ahead and just expedite this. It's all over with. Let's just move forward and get this summary judgment. And I see them do this in cases that have a high balance amount, because they're not going to just pull out without a fight. They're not going to dismiss the case, or they're not going to put everything out on the table when they could potentially win and get a huge victory and have either a garnishment or bank account seizure or garnishment coming through. So when a debt collector sues you in court, because a debt collector chooses to sue you in court, that means that you have the ability to win your case and to put this whole thing away for good, like to be done and over with, so you can move forward in your life, so you can protect your money, so you don't have to have these worries, you can sleep. It helps put all of that stuff to rest and allows you to be able to move forward in your life quicker. During the process, though, it could be frustrating, it could be stressful. They do not run courts on our time. They basically run it on the judge's time. So some of the times you may think that they're rushing. Some of the times you may think that they're taking too long for everything. Basically, all of the cases come down to the documents that they present. If they present faulty documents, you will win your case if you respond to the case appropriately. If you don't respond to it and you just deny everything, you're going to set yourself up for failure, and you're going to set yourself up to get to have a motion for summary judgment placed or submitted to the court. Now, what they're going to do, what I'm going to do, I'm just going to read through what they put in one that we just recently got. The client is trying to decide on if it's in their best interest to continue fighting or to go ahead and move towards settlement. And just so you know, even if you continue fighting, there's always going to be time for settlement. So you might as well go ahead and just fight it, unless you're just not of the mindset of wanting to go to court. Maybe you got to work, maybe, you got other priorities, and you just don't want to find yourself in court having to fight this for yourself. So what they're going to do, and this is after they've sent you the initial summons and you've responded to their summons, if they decided not to dismiss the case based off of your response. Now, in your response, the way to get a case dismissed is to actually put your arguments, your affirmative defense, a real one, not just I deny or not enough information to admit or deny. I'm talking about a real, put forth a real defense, affirmative defense, because then they will know what they're going to have to overcome to be able to continue fighting you for that debt collector lawsuit. Not to say that they won't continue, but it puts you in the it gives you puts you in the best position to win. And if you had the choices between two things, just saying you're going to admit not enough information to admit or deny, or just deny flat out in your initial response, or you could actually have a defense that can make the debt collection attorney think twice about continuing with the court, because they're going to know that it's going to be a fight. Which choice would you make? So that's one of the services that we provide. So if you are being sued by a debt collector, you will have a chance to win that case if you respond to it appropriately. So you can go to my website, thecreditrepairshop.com, upload your summons, and we will review it. And then we will get back with you on the options that are available to you. Now, what they will do after they submit their summons to bring you into court, you submit your response. They may take it to the next step where they'll motion for summary judgment. And so what they're going to do is they're going to have a brief in support, and then they're going to put in their law and argument. And what I've seen Calvary's attorneys use a lot is a case, and it's Temple versus Win United Inc. And basically what it says here, the Ohio Supreme Court decision in Temple versus Win United, Ohio 50 Ohio ST 2D 317 1977. So they're reaching way back. Sets out a criteria for summary judgment. Specifically, the court held that summary judgment should be granted only when there are no genuine issue of material fact and the moving party is entitled to the summary judgment as a matter of law. So now let's talk about how we can counter that. So this is why you're going to have to review your documents. You got to look at the documents. You're going to have to take the emotion out of it, and you have to read these documents for what they are. People tend to, and I put myself in this category, when something is pointed at you, when you read it, you have that emotion, and you are reading it as if someone is like pointing at you, like you did this, this is you, you're responsible. That's the feeling that you have, and that can make you miss a whole bunch of doors that are open for you to be able to fight your case. Now, let's go through the steps to counter that claim. So if you have a debt collection attorney and they have put this case or a case that is similar, that states they're going to put something in there to support their argument that they should be able to get that summary judgment, and they will put a case where it has been decided, and they're going to put that in there, and they want the judge to look at it and say, like, yeah, there's no material fact. So now, obviously, what would be the way to counter that? Like, just straight up, what would be the way to counter it? The way to counter it would be to show that there are material facts that are being disputed. They don't want you to even think that way, because they're going to put latest out there, just like with this client. When she sent this over to me, she was like, I don't know what to do. That's because there's emotion. The number one thing you should do is you should just look at, if you want to just like have a straight line on what you could potentially do, is just simply type in these court cases, and you will be able to see what happened in those court cases, and then you'll be like, this does not apply to me. It only applies to you if you don't review and come up with either, and you have to find other court cases that will counteract this, because the judge is going to want to know, okay, this is a case that happened, and the defendant is going to give a case that happens, and then there's going to be some evidence or some documents that's going to establish what the defense is trying to get across to say that there are material facts. So now let's talk about some of them here, or all of them. I keep saying some of them. So you need to identify disputed facts. You need to carefully review the pleadings, deposition admissions, affidavits, attachments, stuff that they put in your file, like this one here. They put the attachments. You need to carefully review it, and you need to see the discrepancies, what is there and what is not there. Now, I want to say something real quick, and some of you may get upset, but there are certain things that I'm not going to be able to say in this video. I'm going to give you the information. You're going to have to either reach out to us, and we're going to have to know that you're not with the debt collection company, because, hi, Mr. and Mrs. Debt Collector, we all see you, spies, watching the videos, looking in the comment section. And they're trying to reach out to see how we are helping people fight these cases. As a matter of fact, the test on how I know that you are here is because of the way that you did respond to the response that was submitted by one of our clients. I know that you're watching. So for everyone that is here, there are spies here, and the spies, what they're doing is they're trying to get the information so they can see how they can enhance their court summons to be able to stop you from winning your court cases. But you will be able to win your court cases, because regardless of what they come in here and see, this is the factual basis on how you can win your case, and there's nothing that they can do about it if they don't have their documents in order. So now, first you need to identify disputed facts, carefully review the pleadings. Those are the documents that they give you, depositions, if anyone. And as a matter of fact, there is a deposition in here from an employee of Calvary that states that they've reviewed the books with the credit card company. They reviewed the books that was provided to them. They were never inside of the credit card company and said, give me complete books. That's number one. And then any affidavits and any other relevant documents. And then what you need to do is identify facts that are disputed and are material to the case. So anything that you can dispute that is not fully clarified in your own eyes, and then you have to match that up with some other cases that are out there that allow you to establish that there is something for the judge to be able to look at. And then material facts are those that could affect the outcome of the case. So it has to be something that you believe that you can also back up with case law that will allow you to, that could allow the outcomes. The outcome meaning that there could potentially not be a judgment order that the judge would give to the plaintiff. Now, also you may, if you have evidence, you want to provide evidence, present evidence showing that the material facts are genuinely disputed. This can include affidavits, witness statements, documents, and other preeminent evidence. Ensure that the evidence is specific and detailed. That is very important. That's something that the judges will look for. In other videos, I talked about this. It is what makes the difference between your arguments being heard and not being heard is the way that you say it. It needs to be clear and concise. All you have to do is, let me just tell you how you have to do it. Remember when Johnny Cochran said, if it doesn't fit, you must acquit. If it doesn't fit, and he had a glove, you must acquit. Is there any outside of the box thinking with that? So when you make your responses and you make your arguments, it needs to be clear and concise. And you need to show, and you need to highlight any inconsistencies or contradictions in the opposing party's evidence, which there is plenty. There is so much in this one that I'm not even going to say, but you would be able to find those inconsistencies. Then, legal arguments argue that the disputed facts are material to the case's outcome. Explain why these facts are significant and how they impact the legal issue involved. Reference the Temple and Win United case emphasizes the requirement that a summary judgment is inappropriate when there is a genuine issue of material facts. So you can flip that same case around and say that if there is genuine issue with the material facts, using that same case, you flip that around on them and say, hey, it does say that there, but there are genuine material facts that are disputed. The next thing is case law and precedent. Cite additional case laws, and I just talked about that earlier, supporting your position that the summary judgment should not be granted when there are disputed material facts. Draw parallels between your case and similar cases where summary judgments were denied. Highlight inadequacies in the opposing party's motion. Critically examine the opposing party's motion for summary judgment and highlight any deficiencies or oversight. This is something that is very important. That's why I said you got to take the motion out and you got to read through that some motion for summary judgment, and then you're going to have to get your yellow highlighter. Get your yellow highlighter and start marking, and then read through and then go back through again, and you're going to make your arguments. So here's an example that I was able to find. It says that briefly state that the motion for summary judgment should be denied because there are genuine issues of material facts that remain to be litigated. Legal standard for summary judgment. Reference Temple Warren United decision. Explain that the legal standard summary judgment is only appropriate when there is no genuine material fact. Identification of disputed material facts. List the material facts in dispute. Provide evidence for each disputed fact, such as affidavits, disposition, excerpts, documentary evidence, which would be in the way that I've always done it and told people that they should do it is look at the documents that they've submitted to you, because how are they going to back off of their own documents that have deficiencies in them? Significance of disputed facts. Explain why each disputed fact is material. Discuss how facts affect the outcome of the case. Inadequacies in opposition party's motion. Highlight any gaps or weaknesses in the opposing party's evidence or arguments. Argue that the opposing party has not met the burden proving the absence of genuine issues of material facts. So let me talk about some of the things that I want you to look at when you are looking at your case. If they are motioning for summary judgment, I want you to take a good look, number one, at the case that they're using to establish that the case law that they want to use to establish to be able to get the motion for summary judgment. If you're dealing with Calvary, this is the one that they're going to most likely use. Then I want you to look at your exhibits. I want you to look at your bill of sale and assignment. I want you to comb through that, and I want you to make sure that everything is in order. Who originally purchased the debt? Also, what is missing from that document? There is something that is missing from there, and it will be just like a red light when you read it. I cannot say it right here because of the spies, but you can look at that document. Make sure that there's signatures on there. Make sure that if a debt collector purchased it, or if another debt collector purchased it from another debt collector, you need to look at all of that. And then also watch out for something that will be missing. You will see it. Also, other exhibits that they might include is the exhibit from the lot number, and there is something that is also specifically missing on this, and they also will cover up the sale balance and the number of accounts that they did purchase, but there is something that is missing from that. There is something that is missing from that on all of the ones that I've seen. Then they're going to have an affidavit of sale of account. Now, this document is very confusing to people because they try to make you think that this actually 100% pertains to the individual. But again, there is something that is missing from this document that will be like a big red light flashing right in your face. Read it over and think to yourself, something is missing. What is missing? If this was a document about you, what would have to be on there to be about you? That's what I'm going to say about that. Also on this will be your other opportunity where you would need to look at this affidavit of sale account contract. Make sure that that the debt collector is listed on there, and also that it is in order with the bill, with the let me get back to here. Make sure that it is in order with the bill of sale and assignment, and make sure that the dates are appropriate. We've seen them where the dates were out of order, and it was like you are sending a portfolio sale before this individual had even had a charged off account. So make sure the bill of sale and assignment matches with all of the same debt collectors' names on there. And if it was multiple debt collectors, it better be on both sheets, or it needs to be in order. That it needs to be sequential in order, or that's going to be a problem that you'll be able to bring up. But there's also still something that is missing on that document. The next thing is the certificate of conformity. You need to make sure that all of that matches, make sure that the dates match, make sure that there's signatures, everything on there, because the conformity of the documents is something that is required when they sell and transfer documents from these from one company to another. When you review that, then you put you yellow out everything that you see that could be a problem, and then you're going to put your motion together, and then you're going to have to motion to deny summary judgment, and you're going to have to put all of that package, all of that together, submit it to the court, and let the judge make the final decision. All right, if you find yourself in this situation, we can help you. Go to my website, thecreditrepairshop.com. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different. You can watch my 8-point validation process, my two-phase settlement process. Let me back up a little bit. If you need a motion to deny summary judgment, or you need to respond to a court summons, go to my website, go to the live chat, upload your summons for review. We'll follow back up with you. Put your phone number there, because it'll stop the back and forth on the live chat, and we can help you as soon as possible. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different, so you can see my 8-point validation process, my two-phase settlement process. Need your credit reports and scores? Go to the website the3scores.com to grab your TransUnion, Equifax, Experian credit reports, and all 3 scores. That's where everything starts. If you don't know what's on your credit reports, how it's affected you in your life, you are not in the starting blocks. Right now they had the Olympics going on. Everybody starts in the starting block at the same point. And if you are looking to repair your credit, the starting block is getting your credit reports and scores and getting that reviewed. And then keeping that, because number one, you want to see what's the reaction from the bureaus on the work that's being done, and from the furnishers on the work that's being done, but also understanding that this is something that you're going to have to maintain with all of the ID theft stuff that's out there, with all of the different effects that inquiries and having credit card balances change and all that. You want to always be aware of what's going on with your credit. This is like a fee that has been launched upon us, that I have it, I pay for it every month, and I believe that everyone should have it, because if you could get that alert system, you will be able to stop a lot of stuff that's going on, or be able to understand how your credit is being affected with the scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters: statute of limitations letter, debt validation letter, and cease and desist collection activities letter. Use the appropriate ones for your specific situation. Those 3 letters are not to be used if you're being sued by a debt collector. When you're being sued by a debt collector, you have to respond to the court summons. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.